Well, good morning, everyone, and welcome to our latest property dispute webinar. I'm Mary Rouse, and I'm a legal director in the property disputes team. I specialise in all types of residential disputes, from landlord and tenant to boundary and right-of-way issues. Our other speakers this morning. Our other speaker is Hutchinson. Lauren is an associate in the team, and her expertise covers both residential and commercial property disputes, as well as contractual disputes. You'll see from our agenda that we're going to cover a number of topics today, including Section 21 and Section 8 notices, as well as giving you a case update, and of course an update on the Renters Reform Bill. If you have any questions as we go along, please pop these into the Q&A at the bottom and we'll deal with these at the end. So we'll start with the Renters Reform Bill. Now, we deliberately planned this webinar for December in the hope that we'd be able to share some up-to-the-minute information about the progress of the bill with you. And so I'm sorry if you've been awake all night in anticipation, as unfortunately the hoped for announcement has not yet materialised. But we thought it would be useful anyway to go through the bill's progress to date, what's proposed and what we think might happen. So it all began with a consultation in April 2019, when the government consulted on proposals to end no-fault evictions by repealing Section 21 of the Housing Act 1988. It also consulted on extending the grounds for possession under Section 8, removing the landlord's ability to grant new assured short-hold tenancies, or ASTs, and to improve the processing of repossession orders. In November 2019, the Conservative Party manifesto included a commitment to introduce a Renters Reform Bill that would repeal Section 21 and scrap any new ASTs. Things then ground to a bit of a halt, as did everything due to COVID, but it all ramped up again earlier in the year when the government outlined its proposals for the Renters Reform Bill in its A Fairer Private Rented Sector white paper that was released in June 2022. And the government has confirmed that it remains committed to introducing the Renters Reform Bill in this session of Parliament. And this session ends in May 2023. So if that's right, then we're moving ever closer to the proposed changes. Whether Section 21 will be repealed remains to be seen. There's real fear that it would result in fewer properties being available to rent, with buy-to-let landlords opting to sell now for fear of being tied to much longer tenancies and difficulties getting their properties back. For this reason, there's likely to be a considerable amount of opposition. But for now, the government is telling us that Section 21 will go. The proposal is to counter that with grounds for possession under Section 8 of the Housing Act being extended to include a ground for use if the landlord intends to sell their property. This would be coupled with a ban on the landlord from reletting that property for a certain period. So if the property wasn't sold, the landlord would not be able to relet it. This is designed to avoid landlords abusing the ground. Other proposals include making all tenancies periodic with no fixed terms at all, removing the arbitrary rent review clauses and increasing the notice period for rent increases. These two proposals alone, if enacted, will give the landlord a new statutory process to comply with. That's the use of Section 13 of the 1988 Housing Act as the mechanism for increasing rent. There's a prescribed form for this, but it really is quite complicated and it would be very easy to get wrong. preventing a landlord from increasing the rent for another 12 months if it served an incorrect notice. So it's quite a complicated alternative to having a clause in the tenancy agreement which enables you to increase the rent. The other proposals include extending the decent homes standard. Now, this currently only applies to social housing. The intention is to extend it to the private rented sector. Also making it illegal for landlords to have blanket bans on renting to families, for instance, that have children, or on those with benefits. And finally, there's an intention to improve the rights of tenants to have pets in their properties. We could talk about these proposals all day, but many of them are likely to put off landlords with just one buy-to-let or a very small portfolio. It's true that something needs to be done to tackle what we call rogue landlords and to aid tenants who are living in appalling conditions. And the decent homes standards is not onerous for the majority of landlords who look after their properties. But for those whose properties don't meet the standard, tenants will no longer have to pursue lengthy disrepair claims. A tribunal will be able to require landlords to repay rent to tenants whose properties don't comply with the housing health and safety rating system. We're going to look at the existing grounds for mandatory possession a bit later on, but the bill includes a proposal to introduce more mandatory grounds for possession where there are serious rent arrears, and it's likely that we'll see tenants having to give at least 2 months' notice to vacate. So you can see there are 1 or 2 nuggets of comfort for landlords. And at pains to reassure landlords, the white paper boasts of the following measures to support them. It talks about a new private rents ombudsman to enable disputes to be settled quickly at low cost and without going to court. I'm not a pessimist, but we'll see how that goes. Also a property portal offering a single front door to enable landlords to understand and comply with their responsibilities, whilst also giving councils and tenants the information they need to tackle rogue landlords. Again, quite how that will work in practice and who will administer it remains to be seen. There is no doubt that some reform is needed, but those of us who work with decent landlords trying to remove tenants who often know only too well how to play the system may feel that it's a bit of a hammer to crack a nut, with landlords finding it more difficult to obtain possession, as if it wasn't difficult enough. What's being proposed will involve a substantial rewriting of legislation. It's very difficult to repeal one section because of the impact that it will have on other sections. Let's hope that enough time is given to ensure that they get the legislation right so as to avoid the confusion that so often arises when new housing legislation comes in. My best guess is that we won't see any new law until October 2023 at the earliest, and most likely 2024. I'm now going to hand over to Lauren, who's going to talk about Section 21 notices.
Thanks, Mary. Morning, everybody. We thought we would cheer you up a little bit and give you a bit of a refresher session on the notices currently available to landlords. The first topic that I'm going to talk about today is Section 21 notices served pursuant to the Housing Act. This is a mechanism for obtaining possession of a residential property let by assured short-hold tenancies. You may have heard of a Section 21 notice referred to as a no-fault notice. This is simply because a landlord does not have to provide a reason for evicting a tenant using this type of notice. As long as the landlord can show to the court that the notice was validly served, the court must issue a possession order. A Section 21 notice cannot be used to end a tenancy during its fixed term, but can be served to expire in line with the end of that fixed term or beyond the fixed term. In addition, a notice cannot be served in the first 4 months of a tenancy. A Section 21 notice comes with a statutory 2 months notice. So when you serve the notice, you give 2 months notice to the tenant, and if they don't leave, you then proceed with your possession proceedings. There are scenarios whereby longer notice periods are required, and this would need to be considered on a case-by-case basis. To take an example, if you have a 6 months fixed tenancy, you could serve a notice in month 4 of the tenancy for it to expire on the tenancy end date or soon after. Once the tenancy turns periodic, you can serve the notice at any point. A couple of overhead points is you must ensure that a notice is served by or on behalf of the landlord registered at the land registry. There can sometimes be instances where there is a registration gap if the property has recently been purchased, so this must be checked thoroughly. In addition, the notice must be served in accordance with the tenancy agreement. If the agreement says it must be served by carrier pigeon, that's what you do. This notice must also be served on the correct form. The forms do change from time to time, so just proceed with caution on this point. You are probably all very familiar with the Deregulation Act 2015, which applies to all assured short-hold tenancies from the 1st of October 2018. The Act sets out certain requirements for a Section 21 to be validly served. First up is the protection of the deposit. You must ensure that if a deposit is received for a property that is protected in a tenancy deposit scheme and the prescribed information is provided to the tenant within 30 days of receipt of the deposit funds. It's imperative you keep a paper trail of this. The Tenant Fees Act 2019 is now also in play, and this caps the amount of deposit you can take. It's capped at 5 weeks rent where the annual rent is less than 50,000 or 6 weeks rent where the annual rent is 50,000 or more. Any excess payment is known as a prohibited payment, and that must be returned before a Section 21 notice can be served. There are also some implications in the form of civil penalties and compensation for breaching both the Tenant Fees Act and not protecting a deposit, but we don't have time to go into that today. If a deposit is not protected, you cannot retrospectively protect it. You would need to return that deposit before issuing a notice. There are sometimes exceptions to this if you have very old tenancies. This can sometimes be a tricky process because a tenant could try and refuse to accept the deposit back. So before taking this step, it would be advisable to take some advice on the best way to deal with it. Next is energy performance certificates. A landlord must provide a tenant with a valid copy of an EPC at the beginning of a tenancy. If no EPC has been served, then any notice served would be invalid. There's been some recent case law in relation to gas certificates, which I'll discuss with you later, which means you could retrospectively serve the EPC before issuing a Section 21 notice, and that notice could still be valid. Again, you need to deal with this very carefully. So this takes me nicely on to gas safe certificates. In accordance with Regulation 36 of the Gas Safety Installation and Use Regulations 1998, a landlord must provide a gas safety certificate to a tenant at the beginning of the tenancy prior to the occupation. If this is not done, then a certificate can be served retrospectively, but it must be valid at the beginning of the tenancy. I'll expand on that a bit later. A landlord also needs to ensure that the gas is checked every 12 months and a copy of the certificate provided to the tenant within 28 days of that check. However, if a landlord does fail to do that, it doesn't stop a landlord issuing a notice. But again, it has other implications in terms of fines. How to rent booklets should be served at the beginning of a tenancy. And when issuing proceedings, we must exhibit a copy of the booklet served. So keep a paper trail as to exactly which booklet has been served. There are several different versions, so you need to make sure you're serving the most up-to-date version. Unlike the other scenarios, this can be rectified before serving a notice. You would simply send the most up-to-date version to the tenant, but it's imperative this is done before issuing the notice and not at the same time. So only 2 more issues to go. So complaints about the property is also something to be aware of. There is a protection for tenants from eviction where they've raised a legitimate complaint about the condition of a property. If a tenant complains about the property, a landlord or their agent has 14 days to respond and address the issue. If the tenant's not happy with the response, they could refer that complaint to the local authority. and the local authority may serve an improvement notice on the landlord to remedy certain matters in relation to the health and safety of the property. You would be barred from serving a Section 21 notice until 6 months after the date of the improvement notice. If you've already served a Section 21 notice and then you're on the receiving end of an improvement notice, that would also invalidate your Section 21. There are ways that you can appeal an improvement notice if you think it's incorrect, but this would take time. There are also some limited exceptions to this. For instance, if your property is up for sale, you could issue a Section 21 notice, even if there's a current improvement notice or if one follows. It is a little tricky to get around these improvement notices or to confirm if you are indeed exempt. So always take some advice on that point. Finally, the Tenant Fees Act 2019, which I briefly mentioned. This act is in relation to the types and the amounts of payments that can be demanded by a landlord or their agent from tenants. Examples of these prohibitive payments are tenancy setup fees, viewing fees, credit check fees, and checkout fees. If any prohibitive payments are taken from the tenant, they must be returned before a notice can be served. Just like with deposits, some tenants may try and avoid receiving the funds back. So again, get some advice on how best you can deal with refunding that deposit. That was a bit of a whistle-stop tour of how to ensure a Section 21 notice is valid, but you'll see that's imperative that certain deposits are served at the beginning of tenancies to avoid issues down the line. It seems like a lot, but if we can tick the boxes at the outset, it makes life much easier when you do need to obtain possession. So I'll hand back over to Mary and she will give you a bit of an idea about Section 8 notices.
Thanks, Lauren. So Lauren's explained the process whereby you can recover possession if you want to without having to rely on any grounds. I'm going to look at the Section 8 notices, which come from Section 8 of the Housing Act 1988. Now, Section 8 has a much broader reach than Section 21, and it can be used for both assured short-hold tenancies or periodic assured, or as we used to call them, lifetime tenancies. So where you can't use a Section 21 notice, for example, if the tenancy is still inside its fixed term, or where you've missed one of the statutory requirements at the start of the tenancy, then Section 8 is potentially your alternative. Section 8 permits landlords to serve a notice seeking possession where there's been a breach of tenancy or where one of the other grounds for possession is made out. Now, there are 17 grounds, so you'll be pleased to hear that I don't intend to look at every one of them. They divide almost equally into grounds which are mandatory and those that are discretionary. So what does that mean? Well, if a ground is mandatory, this means that as long as you can produce evidence to satisfy the court that the ground is made out, the court must grant a possession order. The court still has some limited discretion, but it can only give a tenant up to a maximum of 6 weeks to vacate under the possession order if a mandatory ground is made out. An example of a mandatory ground would be ground 1, where you might wish to recover possession because you as landlord intend to move back into the property and occupy it again as your main home. Sounds straightforward enough, and a lot of landlords come to us and ask whether they can rely on this ground to get a tenant out before a fixed term has ended. As with everything though, nothing is as straightforward as it seems. What the ground actually says is that the landlord must have given notice in writing to the tenant not later than the start of the tenancy that the landlord might want to recover possession on this ground. There is power for the court to dispense with this requirement if it feels it's just and equitable to do so, but I've yet to come across a case where the notice requirement has been dispensed with. In addition, a landlord can only use this ground if at some time before the start of the tenancy, the landlord, or one of them, if there were more than one, was living at the property as his only or principal home. So he has to have been living there before the tenancy began. So this would make it impossible for a landlord who bought a property as a buy-to-let and never actually lived there from relying on this ground. In summary then, if you want to rely on this ground and you served the appropriate notice at the start of the tenancy and you can satisfy the judge that you are moving back into the property and you need to be ready to explain your reasons for this, then the court must grant you a possession order. Perhaps the most often used mandatory ground is ground 8. This ground specifies that if there are arrears, the equivalent of 2 months or more rent, that's where the rent is paid monthly. If it's paid weekly, it would be 8 weeks or more rent. There has to be that 2 months or 8 weeks at the time the notice is served, and there have to still be 2 months rent arrears at the date of the hearing, even if the arrears have reduced below that level in between time. If both of those things apply, then the court must grant you an outright possession order. You still need to satisfy the court that arrears have accrued and that the right amount of rent was outstanding at both key points, so the date of service of the notice and the date of hearing. But a rent statement is usually sufficient evidence for this. So those are examples of mandatory grounds where the court must give possession. Looking now at the discretionary grounds, these are exactly as they sound. It means the court can award a possession order, but has discretion to do other things, such as adjourn the matter or make an order that is suspended upon certain terms. So let's take as an example a case where a tenant has been persistently late paying rent and a Section 8 notice is served relying on the 2 discretionary grounds. That's ground 10, where there's some rent outstanding on the date the notice is served, and there are still some arrears when the proceedings are issued, so slightly different from ground 8. And then ground 11, where rent is persistently late. So both of these grounds, ground 10 and ground 11, are discretionary grounds. By the time the matter gets to court, let's say the tenant has reduced the arrears, so they're now down to maybe just the equivalent of 1 monthly instalment of rent. Is the judge going to grant a possession order where the arrears are so low? Well, he might do if there's evidence to show that rent is always being paid late, but he does have some other options. So the judge could decide to adjourn the hearing generally without a new date being fixed, as long as the tenant clears the arrears at the rate of X pounds per month on top of the current rent. Alternatively, they may decide that the tenant's payment history is so sporadic that it's appropriate to make a possession order, but one that's suspended as long as the tenant pays rent on time and pays off the arrears, again at the rate of so much per month. So this is the risk if you can only rely on a discretionary ground. The judge has much wider discretion to avoid granting an outright or even a suspended possession order. Another example might be where there's been antisocial behaviour. A tenant's been having late night parties and has been rude and abusive to neighbours. Such behaviour gives the landlord a right to serve a Section 8 notice relying on ground 14, which is the antisocial behaviour ground. Under ground 14, the judge may award possession, particularly if the behaviour has been persistent or is especially serious. The notice must set out clearly what the breaches are, dates and times of any incidents. In these types of cases, it's the evidence which will determine whether a possession order is made or not. And again, the court has wide discretion. So if, for example, as currently happens, the court takes several months to fix a hearing, and if the tenant's behaviour improves in the meantime, the judge may decide that it would be harsh to order possession when service of the notice and issue of the proceedings have clearly served their purpose in modifying the tenant's behaviour. So in those circumstances, a judge may adjourn the proceedings, but there's an ability to restore them, to ask for a new hearing date if there's a further breach. Alternatively, the court could make a suspended possession order with the right to take possession suspended for as long as the tenant behaves himself. On the other hand, if the tenant's behaviour has deteriorated, and as in one of my cases, the tenant has threatened to cut off the neighbour's toes with a hedge trimmer, then the judge can exercise their power the other way and determine that an outright possession order is appropriate. So very much depends on what happens between the point you issue proceedings and the point that the hearing actually takes place. And the longer that period is, there's an opportunity for the tenant to improve things. Just a brief word about the form of notice and notice periods. There is a prescribed form to use for Section 8. The notice you must give the tenant before proceedings can begin varies from ground to ground, and it's important that you make sure you get this right. So, for example, the rent grounds require not less than 2 weeks notice to be given. That's unless your tenancy agreement says something different. Your tenancy agreement can give more notice, it can't give less notice. So if there's a contractual requirement to give more than 2 weeks notice, then you need to give more than 2 weeks notice. If you wanted to rely on ground one that we talked about earlier, where the landlord wants their property back to occupy it himself, the notice period is 2 months. And if you're using ground 14, the antisocial behaviour ground, possession proceedings can start immediately after service of the notice, even if you're also relying on other grounds that require longer notice periods. So ground 14 trumps the other grounds. As you can see, whilst Section 8 widens the possibilities for recovering possession, there are potential pitfalls. And in addition to what I've already covered, there are a few key points to remember. To be able to rely on any ground which relates to a breach of tenancy, there must be a clause relating to that in the tenancy agreement. You can't use the antisocial behaviour ground unless there's a clause which sets out the sort of behaviour that's prohibited. And as with Section 21 notices, the Section 8 notice must be served strictly in accordance with what the tenancy agreement says about service. Finally, I wanted to mention breathing space. For anyone who's not come across this, breathing space is the recently introduced debt respite scheme, which gives someone in debt the right to legal protection from their creditors. So if rent arrears are included on that list, enforcement action cannot be taken in respect of the rent arrears during the breathing space period. And this is administered by the insolvency service. So if you are owed rent arrears and your tenant applies for a breathing space, the insolvency service will notify you. And once you receive notification, you mustn't contact the tenant directly about the rent arrears. The tenant will have a debt advice provider and you need to make contact with them instead. You mustn't serve a notice on the tenant relying on any of the rent arrears grounds. If you've already served a notice, you mustn't start proceedings for possession. And if you've served a notice on the rent grounds and the tenant's then left the property, you still can't try and take possession during the breathing space period. That period lasts usually for about 60 days and the insolvency service will notify you once it's ended. So that's it on Section 8, and I'm going to hand back to Lauren, who's going to do a bit of a case roundup for us.
Thanks, Mary. So I'm just going to have a look at a couple of cases that we've come across recently. So the first one is Northwood Solihull Limited and Fern. So this case was in relation to who could sign a notice when a landlord is a company. The case focused on a Section 8 notice that was served on Mr. Fern and Miss Cook by their landlord and letting agent Northwood Solihull after they stopped paying rent. The tenants sought to challenge the validity of the notice, as they say, under Section 44 of the Companies Act 2006. The Section 8 notice had not been signed by 2 authorised signatories or a company director in the presence of a witness, and that the Section 44 requirements also applied to the deposit certificate for the property. The tenants took their case to the County Court, then the High Court, and finally the Supreme Court. So the High Court judges decided that Section 44 of the Companies Act did not apply to eviction notices, but they did uphold the tenant's claim that it applied to the deposit certificate. That went up to the Court of Appeal, and they ruled in favour of Northwood Solihull on both elements. So they ruled that the Section 8 notice, and also said this would apply to Section 21 notices and tenancy deposit certificates, that they could be signed by any authorised employee of the landlord or the letting agent, or it could be signed in line with Section 44 of the Companies Act. This case was a bit of a worry for us because if the Court of Appeal ruled in favour of the tenant, it could have meant that any notice or deposit certificates which would have to have been signed by 2 authorised signatories or a company director in the presence of the witness. And this could have meant that there were lots of deposit certificates out there that were invalid, which could have a knock-on effect on Section 21 notices being able to be served. And just in general, it would cause a bit of a logistical nightmare for signatures. So that was a good outcome in that case. The second case is Treacle House and Rounceville. So this case has rumbled on for over 2 years, and this was in relation to gas certificates. So as I explained earlier, to serve a valid Section 21 notice, a gas certificate needs to be served at the beginning of the property before the tenant enters occupation. So at first, the legislation appears to suggest that this could not be retrospectively dealt with. If a gas certificate was not served, you couldn't ever serve a Section 21 notice. But this seemed to be very unfair because ultimately it could have been a bit of an admin error of not serving the tenant with a certificate, but the landlord did actually have a valid certificate in their possession. So in February 2017, Miss Rounceville became a tenant, and Treacle House was her landlord. The landlord did not provide a gas safe certificate before the tenant entered occupation, but in November 2017, so after the tenancy began, they provided her with a copy of the certificate, and this certificate was dated January 2017, so before the tenancy began. In May 2018, the landlord served a Section 21 notice and then issued possession proceedings. The tenant defended the claim on the basis she was not served with the gas safe certificate before taking occupation of the property. The County Court dismissed this defence and granted a possession order, but this was appealed and the circuit judge held that the failure to provide a certificate before the tenancy commenced was not capable of being remedied and granted the appeal against the possession order. The matter went to the Court of Appeal and it held that the correct construction of Section 21A and the 2015 regulations was that the time period for compliance with Regulation 36(6)A and B was disapplied. Therefore, a Section 21 notice could be given so long as the landlord had, at any time before serving the notice, before being the key word there, given the tenant a copy of the certificate that was in force before they entered occupation. So we are yet to see what happens if at the beginning of a tenancy there was no valid certificate. We suspect it will simply be you can't use a Section 21 notice and you would need to use a Section 8 ground in order to get possession. There hasn't been a case in relation to EPCs, but the general opinion is that the same principle should apply. If the EPC was valid at the time the tenancy began, then it could be retrospectively served. I'm sure at some point we'll see a case come forward on this, but for the moment we're going forward with applying the same principles. So back to Mary now, just for a little update on where we are with the courts at the moment.
Thanks, Lauren. So we just thought it would be important to mention the issues that we've been having with the county courts, because we're frequently having to explain the position to landlord clients. So one of the biggest issues for landlords who want to recover possession where notice has been served and the tenant hasn't vacated is the delays with the county courts. It's true to say that most courts have not recovered from the backlog caused by COVID-19 and the temporary changes that were introduced to the rules at that time. So if you issue proceedings after service of a Section 21 notice, these will usually be issued under the accelerated procedure. This is a bit of a misnomer at the best of times, but as long as the court doesn't find a reason to list the matter for hearing, you may be lucky in the provincial courts and secure a possession order in 4 or 5 weeks from the date of issue. But remember, the court does have power to suspend that for up to 6 weeks, a maximum of 6 weeks, if the tenant has good grounds for doing so. It's on the grounds of exceptional hardship only. If the tenant still doesn't leave after that, you have to issue a possession warrant. And so even with a following wind, the quickest you're likely to get a property back under the accelerated procedure is about 3 months. In the London courts, you may receive confirmation from the court that your application's been issued and then wait weeks to hear that it's even been served. So expect the process in any of the London courts to take much longer. If you're issuing proceedings on one of the grounds for possession, there's always a hearing. And for the London courts, a wait of 6 months to get a hearing date would not be unusual. Again, the provincial courts are doing better here, but you can still expect to wait around 3 months for a hearing date. And then, if a bailiff is needed to carry out an eviction following the making of a possession order, well, there simply aren't enough of them. There's often one bailiff to cover several courts now, so you will wait quite a long time for an appointment to be fixed. So, in summary, using Section 21 and the accelerated procedure can take you between 3 and 4 months. Using Section 8 may take 6 months or more, and you can expect to add at least another 3 to 4 months to these timings if the property falls into one of the London court's jurisdictions. I should also mention that if a claim becomes defended, as claims following a Section 8 notice often are, it could take up to 18 months to recover possession. So there are a couple of things that you can do to speed things up. Assuming you get a possession order and the case is not defended, then it's possible to apply to the court for the case to be transferred up to the High Court. This will enable you to use the High Court enforcement officers to enforce a possession warrant instead of the county court bailiff. This process is usually much quicker, but again, the court has discretion as to whether to allow a transfer or not, and you would need to provide a good reason. Finally, you may want to do a deal with your tenant, offer some sort of financial incentive to vacate sooner. I appreciate that this might seem unpalatable where there are breaches of tenancy, but it does make commercial sense if you are able to recover your property sooner and also avoid expensive legal fees. However, we would always recommend seeking advice on making an offer, as these need to be really carefully framed. And of course, no money should exchange hands until you have the keys to your property back.
So thanks very much, everyone, for attending. And if we can help at all, then please do just get in contact.